Hello and welcome to the latest episode of the Mitchell Law Tea Break. I'm Catherine Mitchell and I'm joined as usual by Joanne Sefton, our in-house barrister. And today we wanted to talk about what I'm going to controversially describe as malingering.
It's an interesting word, isn't it?
It is interesting for all sorts of reasons and very satisfying to say. It comes from the French and the definition is the fabricating of symptoms of medical or physical disorders for a variety of reasons, such as financial compensation or avoiding school or work.
Imagine.
Yeah, in my extensive research for today, I also consulted the publication Psychology Today, and that told me that malingering is not a psychiatric disorder.
It's those situations where we think there's a possibility that someone who is reported sick, perhaps for disingenuous reasons, and that's what we're going to be talking about today.
Yeah, so we're not proposing to encourage a wholesale crackdown on sickness absence across the country.
No, and interestingly, the Office for National Statistics reported in 2018 that the average number of sickness absence days has actually halved since they started keeping records in 1993. But reasons for that, and whether we've got an epidemic of presenteeism or perhaps for another tea break. Today we're talking about those cases where you have a concern as to whether the person is genuinely sick.
Yeah, although it's fair to say that some of the advice about procedure will be equally relevant for dealing with the absence of people who are off sick for good reason.
Yeah, definitely. Advice about following process, being consistent, applying judgment, keeping good records of all communications, that applies across the board. So to turn to those cases where an employer has doubts about the truthfulness of the reasons given for sickness absence, one we see on a regular basis is where the employee is being invited to disciplinary investigations, isn't it?
So the hapless employee who hears that he's being investigated and would prefer not to face the music, so calls in sick. Then a week passes and a fit note is produced citing stress at work. This is one where we're often called in to advise, isn't it?
Yes, and it is a tricky one, and a lack of confidence in how to handle it can make matters worse easily and lead to them unravelling further. It's a rare case where it's in the employee's interest to allow things to linger, though we do know of cases where a rogue employee has tried to stay at home on full sick pay for an extended period instead of facing up to the allegations.
Yeah, and the advice generally is to look at the background, but don't assume that you have to wait until the employee chooses to come back to work. And there's clearly a need to tread carefully if the employee has known mental health issues. Or a particular vulnerability, and indeed the employer will always owe a duty of care to any employee not to take risks with their health.
But where you have someone who does appear to be avoiding matters, a simple workplace stress sickness note isn't necessarily going to help them.
No, and I could get on my hobby horse here and say stress isn't an illness, and our psychologist friends I'm sure would tell us that a reasonable amount of stress is desirable and we wouldn't get out of bed in the morning without it. And it's when stress gets out of control and leads to a recognisable mental or physical condition that there's a problem. And if I'm called to a disciplinary hearing and feel stressed about it, that's entirely understandable, but it doesn't mean I'm sick and should stay off work.
You finished on that one?
Yes, thanks.
So very often, medical advice is that a person who is facing disciplinary allegations and is understandably stressed about that should in fact attend the meetings and then deal with that underlying source of stress.
Yeah, and we're very often involved in cases like this, and the first port of call is obviously to communicate directly with the employee themselves and try to establish a little more about the illness.
Yeah, and there's no point going in all guns blazing if in actual fact a simple phone call would reassure them, answer some questions and let them know it's worth coming to the hearing.
And a letter inviting them to come in, explaining that we understand they're off sick, but unless there is another significant factor, we think it's likely that dealing with the issue that's making them stressed is more likely to lead to them being able to move on. And in some cases we do see employees refusing to attend when it appears that it would be in the interests of all parties simply to get on with things and wrap up the process.
Yes, and very often, of course, this is the point where an occupational health advisor is drafted in to advise on whether an employee is fit to attend a disciplinary hearing. And I think there's some helpful official guidance on that, isn't there?
Yeah, there is. The Health and Work Handbook, produced by such august bodies as the Faculty of Occupational Medicine and the Royal College of GPs, it sets out that a GP statement is strong evidence of incapacity unless there is evidence to the contrary. So if the employer is not confident about what the GP is stating, and we do have to remember that the GP's primary duty is to their patient, then the employer is entitled to consult an occupational health physician. And if there's disagreement between that occupational health physician and the GP, the guidance states that the employer is entitled to make decisions on what it considers to be the most appropriate evidence. Goes on to state that it's likely to be the occupational health view because of their knowledge of the workplace.
So in a nutshell then, occupational health can trump the GP's view?
Well, I hesitate to oversimplify, but yes.
Okay, so let's say we get a report from an occupational health consultant saying that Bob is, on balance, not fit to attend and do a normal day's work, but he is fit to come to this meeting. What happens next?
Well, I say we invite Bob into the disciplinary hearing. We give him the usual notice provision, so at least 48 hours if we think there's a possibility of dismissal. And if we think there is a possibility of him losing his job, we tell him in the letter, and we invite him to bring his favourite trade union rep or a work colleague.
And Bob says he wants to bring his sister-in-law. How do we feel about that?
Well, we don't really like it, unless he has a disability and we're considering it as a reasonable adjustment. All of us old hacks have had experiences where an employee tries to bring their very experienced HR friend or even a solicitor or barrister, and the risk of this is that it moves things a long way from the internal process it's supposed to be, even possibly starting to feel like a court case. So the advice is always ask who Bob's bringing and satisfy yourself that this is someone who fits the definition of who he has the right to bring unless he's disabled.
Okay, and what about the case where we do invite him and he still doesn't turn up and says he's sick?
Well, I think contact him again, explaining very clearly that we've had medical advice that says he can come, and we might also be tempted to tell him that we might make a decision in his absence if he doesn't attend.
Yeah, that's never ideal for anyone, is it?
No, and it's a fundamental principle of natural justice that somebody should have the opportunity of hearing the allegations against them and putting their case to the person making the decision. But there are times when an employee like Bob makes this challenging.
Another aspect to mention is the role that sick pay can play in these sort of cases.
Yeah, and if your business pays enhanced sick pay and you've got a really good sickness absence policy, it will include provisions that company sick pay won't be provided for someone who goes off sick in the face of a disciplinary investigation.
Okay, and the benefit of that is that very often it can be the money that unlocks the problem, can't it?
Yeah, and call me an old cynic, but there are times when HR is unconvinced about a genuine absence, can't get the employee in to face the music, but then pay is switched off and they do get in contact.
And broadening that out to problematic absence more generally, it is sometimes the money that talks, and that can be the way through.
Yeah, and it's worth remembering that employers are entitled to withhold even SSP, let alone enhanced sick pay, if the employee doesn't comply with sickness procedures.
I agree. It's just one of the tools that an HR team can use if they are struggling with someone who keeps on pressing the buttons.
Yeah, it is. And before we finish, that HR person who is dealing with a chronic absence issue, which she's not convinced is related to a genuine health problem, she's now at the end of her tether, but what else does she have available to her?
Well, it often comes back to the data, making sure that's as accurate as possible, including notes of return to work, interviews, communications with the employee, whether you've phoned them up, and of course the occupational health specialist, and not least also you've got your disciplinary policy.
So not always the absence policy?
Well, not always, sometimes, and in the heat of dealing with one of these ongoing absence issues, if you're convinced that there is mischief in here and someone isn't actually sick, and you feel that you can prove it to a reasonable level of proof, then you are entitled to go in with the disciplinary policy, because at that point it becomes about their conduct rather than about their capability.
Yeah, I agree. And we could spend much longer on this. We've got plenty of war stories to share. My top malingering case, it gives me no pleasure to say, but I've dealt with 2 cases of an employee claiming to have cancer, but they were later found to have no such thing, and they used the natural sympathy of their colleagues to breathtaking effect, and ended up embezzling thousands out of the business by a variety of ways.
Oh, that's quite full on. What to take away from that then?
I'd say always ask questions and ask for a footnote, even in those situations where it feels really insensitive and problematic to do so.
Okay. Well, on that note, we'll bring this tea break to a close. Thank you very much for joining us, and we hope to see you again soon.
Thank you.